Well, a hush has come over the room quite appropriately, right on cue. It's, I think, just turned 4:30 p.m. And are we now live streaming? Good. Okay, we're live streaming this afternoon. We have 441 online registrants and a good sized group in our room as well. So thank you everyone for attending the Advocacy Center for the Elderly ACE special lecture on a lawyer's standard of care to vulnerable older clients, recognizing and preventing exploitative and abusive property transactions. I'm Graham Webb. I'm a lawyer and the executive director of the Advocacy Center for the Elderly. And you're not here to hear from me, you're here to hear from our panel. And I'd like to introduce our panel in reverse order of their presentation. To my immediate right, to your left, is Ken Doring, the Manager of Investigative Services at the Law Society of Ontario. Joel Kadish, who is a real estate lawyer and an educator, the principal of Kadish Law PC, and Joel was an expert witness who gave evidence in the Harrison decision that we'll hear about this afternoon. To Joel's right is Greg Whedon, founder and principal of Whedon Law, who's done an amazing amount of work over the past several years, acting on behalf of victims of mortgage fraud transactions. And to Greg's right is our own staff litigation lawyer at the Advocacy Center, Bethany Pascudo, who since she joined us more than a year, almost 2 years ago, has been working nonstop on mortgage fraud issues and has a lot of valuable insight to share with us. I'm going to pass down the flicker to Bethany, and we're going to ask Bethany to open up as our first speaker. Thank you. So Bethany, you just point the speaker. There you go.
Magic. Okay.
Right in front of you.
Yeah, thank you. Thank you, Graham. So as Graham mentioned, I'm Bethany Pascudo. I'm a staff litigation lawyer at the Advocacy Center for the Elderly. I thought I'd start off by just saying a little bit about who ACE is and why we are co-presenting this special lecture. So we are a specialty legal clinic funded by Legal Aid Ontario, and we provide legal services on seniors issues and on certain seniors issues. So please don't all call us tomorrow. We have a litigation team and an institutional team. The institutional team deals with issues related to hospitals and long-term care homes, as well as substitute decision-making in those settings. And the litigation team really deals with anything that falls outside the institutional team's area of expertise, issues with pensions and income, elder abuse, retirement homes, etc. We don't draft wills or power of attorney documents, but we can provide legal information on those documents. And over the last several years, we have become unwitting subject matter experts on door-to-door sales fraud and mortgage fraud. So historically, and we still see these cases today, the type of elder financial abuse and property transactions that came to ACE's attention were often coming from somebody in the senior's life, whether it's a family, a friend, a neighbor, an attorney for property. And we would see things like property transfers, where an adult child convinces a parent to transfer the home into their name. And perhaps the parent is doing this under duress or under influence, or is being promised something in return. They're bringing that parent into a lawyer. That lawyer is doing that transfer, and perhaps there's no independent legal advice, or if there is, it's done on a very cursory basis. We also saw the POA or family or friends arranging for mortgages on senior homes. So, and if it's someone acting in their capacity as an attorney for property, they're able to use that document to arrange a mortgage on the senior's home. Perhaps the senior knows nothing about it, isn't even involved in the conversation with a lawyer. And then we saw sales in a lot of cases where properties are being sold because somebody in the senior's life is convincing them that they need to do that. Whether or not that's necessary, it's not really the problem. The problem occurs when that person in the senior's life takes the proceeds of the sale. And again, we see that person taking the senior to the lawyer's office, some indication here of undue influence or duress. The lawyer does not speak to the dad alone about what they want if they actually want to sell the home, and there's no discussion about what's going to happen with the proceeds of the sale. And the fourth kind of general category we would see is gifts. So a senior sells their own property, then loans that money to their adult children to purchase their own property. There's no written record of this transaction. There's no written loan agreement. And the money itself is classified as a gift by the lawyer doing the transaction on behalf of the children. And that's so that the transaction can close and those adult children can qualify for a mortgage. However, in the more recent years, we have been dealing with a different category of elder financial abuse in property transactions. And this is the NOSI and the mortgage fraud scheme that we're generally here to talk about today. So late in 2021, ACE started getting intakes from seniors who had discovered that they had a mortgage on their property, or a family member had discovered that they knew nothing about. Karen Stewart, who was in my role at the time, was taking these intakes, and she noticed the same names coming up over and over again. At that point, ACE was retained to investigate. So to investigate the issues, and we started to do that, and began Karen, working along with Julie Patterson, who was a law clerk at Moore Caruso, began an investigation that uncovered a web of relationships between the responsible parties. We also, or Karen, on behalf of ACE, also made a large number of complaints to the LSO and FSRA about the lawyers and the mortgage brokers who we noticed were involved in this matter. ACE also coordinated with the police and provided them with information and documentation where we had it and on the consent of our clients. And one of the big things that Karen had done is she had worked tirelessly and reached out to firms all across the province to try to find representation for seniors. At that point, ACE wasn't in the position to be taking up representation on their own. And unfortunately, the vast majority of firms were conflicted out, whether it's because they did work for Law Pro or had represented one of the door-to-door sales companies or financing companies at some point. But there were some firms that did step up and agreed to assist on a pro bono or a reduced fee basis. And some victims were, I guess, lucky enough to have title insurance policies where the title insurers, in fact, were convinced to take a coverage position. And as well, as I mentioned, a lot of work with the police, filing reports with the various police agencies, and eventually working with the OPP Serious Fraud Division. The other thing that we were really focused on, as well as Greg Whedon, was legislative advocacy. That eventually led to the passing of Bill 200, which got rid of, made NOSIs expired, which is has led to a whole other issue, but at least we were successful on that. Right now, ACE is representing a very high volume of mortgage fraud victims from this particular NOSI mortgage fraud scheme. And this is a huge access to justice issue that this is really highlighted. These individuals were targeted because they are vulnerable and low income and cannot afford legal representation. The fraudsters thought they could get away with it because these people could not access justice. Unfortunately, we are just one organization with two lawyers doing litigation. It is a lot for our system to handle, and this has really exposed another issue, another access to justice issue that we're facing in this province. So I'm going to quickly run you through how this NOSI and mortgage fraud scheme worked. So the first stage was the door-to-door sales fraud and NOSI registration. As I mentioned, vulnerable seniors were targeted, and we saw the same seniors being targeted over and over again. Once you were on this list of someone who'd been duped into signing one of these contracts, you were re-victimized. There was a list, it was sold or stolen or borrowed among these companies. And we saw situations where the same HVAC equipment was sold repeatedly. So someone's buying a HEPA filter in January, suddenly a new company is coming 6 months later and selling them a HEPA filter again. And the contracts were incredibly predatory, multiple values of what the HVAC equipment was worth. And in most, if not many, if not all the cases, these seniors were misled into these contracts through fraudulent misrepresentations. We've heard story after story about the salespeople saying they're working for the government, they're working with Enbridge. Because you're a senior, you qualify for rebates. You're going to get all this paid off in 6 months. You're going to save money on your bills. We're going to take care of all the other equipment. Like if you currently have a rental with Reliance, we'll deal with that. Don't worry. They're not told anything about the financing company, and often don't even know that the financing, the name of the financing company or that financing is involved. And we would often see that these HVAC companies would shut down after doing this for 6 to 9 months, and the same people would then shift and start up a new company in a different name. And then the financing companies who had provided financing for these contracts would register a notice of security interest on title to the senior's home. This is supposed to be just a notice that there is somebody owns an interest in a piece of equipment that's in the home. Ultimately, though, it was misused and acted as a lien, and we'll see in the further stages, paid out through the proceeds of mortgages or micromortgages, or when the home was sold. We have seen parcel registers with more than 15 NOCs, many for the same equipment, and for shocking amounts, like $40,000 for a furnace as an example. So in the second stage, and the stage 2 didn't happen in every single situation or in every single case, but we did see this a lot. We saw the NOCs being registered, and then following the NOCs would be a micro mortgage. And again, people would be targeted with a door-to-door sales. They'd be sold these so-called whole home renovations. And I can give you some examples. A whole home surge protection, which would cost you thousands of dollars, was a power bar. A whole home gutter protection would cost you, again, thousands of dollars. Involved putting mesh on top of a gutter full of leaves and therefore trapping the leaves in the gutter. And these whole home renovations were again financed by a company that is a different company than the home renovation company. And we would see them charging or registering micromortgages of $31,000 for renovations that were done in a couple hours at best. And then in a lot of these micromortgages, within a week or two, were assigned to another party, to an investor, which makes things very difficult under the Land Titles Act, as I'm sure a lot of us are aware. And then the third stage was mortgages. The senior was approached by someone we would call a fixer, who would arrange a mortgage to pay off the NOCs and the micromortgages. And in most cases, the senior did not have the ability to understand complex financial transactions, perhaps had capacity issues, or was misled into signing documents that they didn't, that they were told were something else entirely. These mortgages were all short-term, high interest, high fees, 1-year term, prepaid interest, huge amounts of broker fees and lender fees. And the purpose of that was to give the fraudsters a year time period where the fraud wouldn't be discovered, because it's not until the mortgage matures and the senior gets some sort of enforcement notice from the lender that they then realize that they had a mortgage. There were 40 mortgages done by a company called Canada's Choice Investments. That company is a company run by an individual named Anas Ayub, who is wanted on a Canada-wide warrant and has fled the country. There were also other lenders, unfortunately, though, that say that they are innocent third-party lenders, and those cases are even more difficult. And the proceeds from these mortgages would be, as I mentioned, would pay off NOCs and micromortgages. And Canada's Choice Capital, another Anas Ayub company, was one of the main beneficiaries. I want to make it clear, though, that there were many other NOC holders and micromortgage holders who got paid out by this scheme. And then if there were any remaining proceeds from these mortgages, they were paid to a quote unquote home renovation company that absconded with the funds, and no renovations would ever be done. As well, in many of these cases, we saw multiple refinancings in quick succession, 3 to 4 mortgages within a period of 18 months, increasing in value from $200,000 to $940,000. And each subsequent mortgage would pay off the previous mortgage. We started noticing that there were the same lawyers representing the lenders and the same names of the lawyers representing lenders, and as well as a separate group of lawyers representing the borrowers and providing independent legal advice. And this is one of the patterns that Karen recognized early on and that we continue to see. And Danielle Harrison's name is familiar to us all. And she is the name we have seen on most of our client files. But she's not the only lawyer who provided so-called independent legal advice to the victims of this mortgage fraud. I won't say their names. Hopefully they'll become familiar to us all soon. But I mention this because it's important to understand that Danielle Harrison is not just one bad apple, but this is a systemic issue. And there were a lot of lawyers involved in these frauds. And I'm going to pass it on to, I'm going to skip this and pass it on here.
Which one?
To you. Yes, Greg. Yeah.
All right. Thank you, Beth. Good afternoon. I'm Greg Whedon, principal owner of Whedon Law. First, thanks, ACE, for putting this event on. Just wanted to make it known that the work that that's done at ACE, the lawyers that are involved, Beth being one of them, Karen Stewart, who's moved on, but they do great work. They're in the trenches with us at all times, and they've been critical to uncovering the scheme and dealing with it. So kudos to ACE, and thank you guys very much. And thanks to OBA for hosting, Law Society for partnering. It's a great, timely, important topic that we have to deal with here today. So I'll just start off a bit about what I do. I'm a real estate litigator, certified specialist in both designations of real estate and civil litigation. So we do a lot of real estate-based fraud, mortgage fraud. So we came across these files probably early 21. The first case that we had was an elderly gentleman came into our office, probably in his late 70s, early 80s. With his granddaughter. They had no idea what was going on, but they had an eviction notice on the front door from the sheriff's office. Started doing title searches and uncovering this. Probably spent about 100 hours in the first few weeks trying to figure out what exactly was happening here. Probably could spend a lifetime trying to figure out the exact fraud, because there's a lot of layers to this problem. But this gentleman was clearly taken advantage of. He had 12 nosies registered on title in a span of about 6.5 months, totaling more than the value of the property. Many of them, like Beth mentioned, were for home HVAC equipment, like 4 water filters. It was clearly that there was something going on here, and he was being targeted. He was isolated. He didn't. It was during COVID, so a lot of these cases happened, during summer of 21, where everybody was in lockdowns and families weren't checking up on their parents and so on. So they were really victimized. And a lot of the cases that you'll see, a lot of the cases that Harrison was involved in were during that span. But in this file specifically, they were converted into a mortgage, I think 2 mortgages, all prepaid interest, 25% interest, after fees and et cetera, lender fees, came out to about 45 to 50% APR in the first year alone. The family had no idea about it. There weren't payments coming out of his account every month because there was all prepaid interest. Someone served him at the door with an eviction notice and default judgment. That's when we jumped in. We set aside the default judgment, and we just settled that case probably about 6 months ago. But unfortunately, that gentleman did pass away a few weeks before that case was settled. But it's not going to be all doom and gloom today, trust me. But the silver lining to that case was that that case really spearheaded my involvement into it, and also it was a great example that the media picked up. Also, A lot of, it was an easy example of how everybody, the society was really, intrigued and trying to figure out how do we solve this problem. And the government listened. So we lobbied hard. Beth, for example, Julie, a few members of law enforcement, a number of lawyers were involved in the lobbying efforts. And that led to the Bill 200, which got rid of nosies. So to say, they're deemed retroactive, which we'll talk about in a bit. But that's the silver lining of that case, how I got involved in it. But it's just one of many. So we'll talk about the kind of common thread, which unfortunately had to do with Danielle Harrison. But we'll talk about that in a bit. But I'm here today to talk about what the tribunal decided, and just take you through the 4 findings, and then pass it over to Joel to talk about more important things. So we'll go first through why the decision matters. I've already kind of touched on it a bit, but it's not only about one lawyer, as Beth said. This was a systemic problem. There was multiple lawyers involved. There were common threads amongst them, but multiple mortgage brokers, real estate agents. Like, this was a pattern of behavior for professionals that should have never happened. They only targeted vulnerable seniors. There were some non-seniors, but they didn't have capacity. The gentleman that I mentioned before had a brain aneurysm 20 years before. He was literally missing half of his skull. He was a yes man, so if you could have sold him anything at the door, he would have taken it. So he was just obviously he was preyed upon, and a lot of these victims are pretty clear that if you walked into a competent lawyer's office, they would have not taken the file. They probably would have reported it to the police. But unfortunately, not all lawyers are at that caliber. So they were all, seniors, fixed incomes, all isolated, like I said, all drawn into these exploitative transactions. So we'll go through some of the 4 of the findings that the tribunal found. So what we'll do is, Beth walked you through like what the scheme was, the nosy scheme, converting it to micro mortgages or mortgages. That was really the gist of it. But how did Harrison play a role in that? That's what I'm here to talk about today. So first, the tribunal went through really like an escalating level of culpability. So they found, at the end of the day, they found that she was complicit. Excuse me. That she was complicit or had actual knowledge of the fraud at the end of the day, or the fraudulent transactions. But they found that she moved through that pattern of culpability from being naive, being a dupe, and then from to recklessness, and then willful blindness, and then to actually being complicit in the fraud itself. So it was an interesting decision to take in and summarize, because it really shows like how the pattern of involvement in something can, like, as a lawyer, you can really get into it, and the consequences of where that's going to end up, which I don't think we know yet where that's going to end up yet, because the tribunal hasn't sentenced yet or done anything, but it's pretty clear that Harrison's not going to be a lawyer anymore. So that was one thing about being involved in the fraudulent transactions. The tribunal also found that she was swearing false declarations, which we'll get through in a few minutes. And then also there's a common theme here of breach of integrity as one of the common elements here throughout all of these. Mainly, when the investigation started happening, when the Law Society started investigating, which we'll talk about later on today. She was concealing records, concealing trust account information. She opened up a shadow practice outside of her firm that she was working with. She was working with KMB, and she opened up a shadow practice and was siphoning off deals through that practice later on. So at the end of the day, she had a clear breach of a significant amount of her duties, but for sure integrity was out the window. So finding number 1, briefly talked about it, but she was facilitating the fraudulent conduct. So the tribunal goes through very clearly that there was a key finding here, that she was facilitating the conduct, and they show how over time it was escalating, which is very important to actually take in. Because one thing just to find that she's culpable of something, but to show the pattern of how she got there was interesting, and at least kind of scary, to be honest with you. But from February to June 2021, which is probably around where I got involved with it, I had the pleasure of talking to her about a few of these files around that time when I was first getting into it. But she was claimed to be, or the tribunal found that she was naive. So she was a dupe. She was doing a few of these transactions. I think she did maybe 5 transactions during this span of time. All the transactions, if you ask me, were pretty clear that there was a fraud going on, but there was no finding that during that short window that she was complicit in it. Fast forward, around fall of 2021, she had several of these transactions by that time, probably 20 or 30 by that time. And they all had serious red flags. So we're talking 25% interest, like all the indicators that all elderly citizens, all, isolated, been pretty clear at that point in time that there was a problem that should have been identified by a lawyer, but it wasn't. So fast forward December 21, backing up. So she first was naive. Second, that they found that she was reckless during that time. Fast forward to December 21. The tribunal found that she had direct warnings. So there was warnings from title insurers that, your policies are getting rejected. There's too many red flags here. She would go to another title insurer and she would get title insurance from a different title insurer. She had law society complaints going on. And, at the end of the day, she was on notice of these problems, and they found that she was being reckless, and no, she's willfully blind at that point. Then she pushed everything through her shadow corporation. And at that point, they found that she did a few transactions then. So she was complicit in it. She was knowingly assisting in the fraud. So that's the first major finding. Second finding was the conflict of interest. And it was pretty clear that she was in a major conflict the whole time. She and her team were registering these nosies on title, like hundreds, probably thousands of these nosies were registered by KNB at her hand. And for a company called CCC, Canada's Choice Capital, which Beth briefly discussed, she would then represent either the borrower or the lender, who in this case was CCI, Canada's Choice Investment. And then she'd pay these nosies out with that mortgage. Wouldn't tell the borrower, wouldn't tell the senior, or she would, but they had no capacity to even enter into a mortgage transaction. So she was literally facilitating those payouts and just paying them out blindly to her current and previous client without disclosing that conflict, which is a huge problem. And, the tribunal found that it was a textbook conflict of interest case. And I have a chart here. I'm not sure if you can see it or not, but this is a chart that we put together as the lawyers who are working on these files. This is just 40 of the transactions that we identified over a period of about 6 months to a year. And you'll see they all have the same characteristics, all 25% interest, prepaid, APR close to 40%, lender's fee, legal fees, same lawyers involved. You'll see on Harrison was representing the seniors at first. Right when she started getting complaints from the Law Society and so on, she shifted over to working for the lenders, and still no conflict of interest was disclosed. Finding number 3, false declarations. This one's pretty straightforward. She was like these mortgages that were being procured. They all had conditions that you can't have construction. You can't use the funds for construction. But she knew that she registered the nosies on title for renovations like 2 weeks or a month earlier. So she knew that the mortgages were being used for construction purposes, and she had her clients, the borrowers, sign off on declarations that there were that the funds would not be used for renovations. So she knowingly assisted in a client signing a false declaration. Breach of integrity. Finding 4, it was integrity through her shadow practice. So when she was on notice from her employer that stop doing these transactions, she shifted to she opened up a professional corporation. She had various excuses for doing that. I don't believe any of them. But at the end of the day, she opened up an under the table practice to try to essentially complete these transactions, maintain lender loyalty, I think is that word that they were using in the tribunal's findings. But at the end of the day, it was pretty clear that she was doing it for her own personal benefit and her own greed. And that's essentially what the tribunal found, that she was doing this intentionally, and it was a profound failure of integrity. And integrity at the core, again, that's really what's weaved through this whole the whole tribunal's findings here. She, by the time that we got into this, the misconduct was pretty clear. It wasn't just missing red flags. We're talking about, clearly having knowledge that there was a problem. And she really, at the end of the day, she was misleading the regulator. She was lying to the Law Society Tribunal or Tribunal, the investigators, and hiding certain trust accounts, et cetera. So that really came around to bite her, at the end of the day. And it wasn't really just about inexperience. It was about, she claimed it was inexperience, but it wasn't about that. She knew what she was doing, and the tribunal highlighted that. Human cost, I kind of already touched on this through my example earlier on, but these files do impact, our parents, like the most vulnerable people in this society, and it's really despicable what happened and how it is happening, and it's still happening. And we need to actually do something about it. So it's great that things are being done, but there is a lot of work to do. The tribunal's finding is one thing. She's going to lose her license, but then she's up on criminal charges. But at the end of the day, this is just one of the lawyers, and there's a lot of them out there. I can tell you that. So some positive part about this conversation is that the reform and response, I already touched on it very briefly, but Homeowner Protection Act was a multi-party success. It really cut this fraud off at the knees. At least the nosy scheme, it was cut off. And but at the end of the day, there's going to be new frauds that are going to be evolving here. There's going to be new ways, new technologies. So this is just one of the success stories in this whole thing. And it's important to kind of highlight that as well, because a lot of the players that are here today, had a large part in that. And the tribunal noticed that that these nosies were kind of the gateways to this fraud. Okay, I've hit my cap already, and I think I went over it. So I think the key part about the tribunal's hearings were that that lawyers are supposed to be the gatekeepers here. And in some instances they weren't, and when they fail in that role, that power that we do have, it really impacts not just the lawyer that loses their license, but the thousands of people and families, our parents, like anybody that the most vulnerable people in the society. It impacts them. It impacts our profession and everybody as well. So falling short and not being on guard of these problems is a huge problem that we all have to kind of identify. So I've been through what her role in it, and Beth's been through what the scheme was. I'm going to pass it over to Joel here to figure out what you should do in what you should not do or what you should do as a competent solicitor in this area.
It's actually just a reasonably competent solicitor. I don't want to overdo it. So you know what's really interesting? As I sit here, my name's Joel Kadish Law Professional Corporation, and I was an expert at Harrison for the Law Society. But what strikes me immediately is, as Bethany and Greg were speaking, is the amount of jargon that we use on a day-to-day basis. And I'm also going to talk about the benefits of being old. One of the benefits for me of being old, called to the bar in 1990, is that I practiced before TerraView. So before electronic registration, we used to go to a physical registry office, and we used to stand in front of a clerk who would actually stamp things, and we'd exchange keys and money right there on transactions. So because I have the benefit of being old, I've also gone through a lot of these systems. And the one thing I can tell you is that this is not just about vulnerable communities. My law clerk, Aidan McLean, has worked for me for 20 years. I helped him buy his first house in Ajax. On the day he closed his transaction, he called me and he said, my wife's in a panic. There's a man here standing on the driveway saying that he wants to replace the hot water tank and he's going to do it for free. Mm-hmm. And I said, tell him to get off your property and that you're going to call the police for trespass. But had Aidan not made that call, he might have found quite easily that his property was encumbered by a notice of security interest, nosy notice of security interest. The notice of security interest is born from another piece of legislation called the Personal Property Security Act, the PPSA. And how it's born is that, it was rarely used. It was used only for hot water tanks. A piece of equipment that attaches to your house. So it's not a chattel. A chattel is immovable. A chair is a chattel. A fixture is something that's attached, can't be taken out. Wall-to-wall carpeting, your furnace, your hot water tank. So the hot water tank company said, well, you know what, we're going to have people sign a service contract and then they're going to have to pay $42 a month. And usually it was through Enbridge, all respectable companies. And they started registering these things under the Personal Property Security Act which we affectionately called nosies. So then we had door knockers, right? Door-to-door salespeople. And we saw people who had nosies registered for light bulbs, as an example, high efficiency light bulbs. So all of a sudden the nosy starts to expand. And the bad people say, hey, we can really jump on vulnerable communities and regular people to have their properties encumbered. And I don't know how many of you use dry cleaners. Probably a lot of you use dry cleaners. And a dry cleaner gives you a receipt. And on the back of the receipt is a lot of small print, of course, which no one ever reads. And when people signed for their hot water tanks, their light bulbs, their water filters, they didn't realize that on the back of that, it said, oh, we can register a notice of security interest under the PPSA against the title to your house. Unlike a mortgage, you don't have to sign anything for this registration. You don't get legal advice. So it gave them the automatic right to register. And we were finding, as time passed, the bar was finding, hey, oh my gosh, a client would be selling their property. There'd be 3 notice of security interest. You'd call the client and say, by the way, what are these? And they'd say, we have no idea. I know I make a payment every month for X, Y, and Z, but I had no idea that it was registered against title to my property. And you may have heard this term also bandied about called micro mortgage. A micro mortgage is just a mortgage, right? What's the difference between a loan? I owe you, right? So I owe you $5. Will you pay me back $5? Sure, thank you so much. So now I know I'm going to get my $5 back. That's a contract, right? The difference between a loan, I owe you, and a mortgage is just that the mortgage secures land, right? So when we borrow money, we use our land as security for the repayments of that loan. It's fundamental, but I think you have to understand that. But the Law Society has a funny rule. It says that if there's a mortgage that's a small amount, let's say it used to be 50,000 and now it's 75, they changed the rule, 75,000, one lawyer can act for both parties. Interesting. So I ask all the lawyers listening to me today, because the rule says one lawyer can act, the question is, should one lawyer act? Or should someone be sent out for independent legal advice or independent legal representation? If you want me to talk about the difference between independent legal advice and independent legal representation, we'll be here for breakfast. Yeah, we'll probably be here for breakfast. So I'm not going to do that today. So I suppose the one thing is, what did I do in Harrison? well, I was an expert for the Law Society. The interesting thing is I don't know anything about Harrison. I have no idea who she is. I have no idea actually what the facts are. I know what the Law Society said, but my retainer was very particular. I was asked a series of questions about interest rates at a certain time, about micro mortgages, about notices of security interest, and I answered them in writing. And that was put before the tribunal. So unlike a lot of the other people who are sitting here with me, I don't know a lot about it. I really think my job in this case was to educate the tribunal members. My testimony was uncontroverted. In other words, I was not cross-examined. Harrison had counsel at the tribunal, and counsel certainly had an opportunity to review my report and had an opportunity to cross-examine me and did not. I think the reason they didn't was because the questions and the answers were factual, based in law and statute. It's kind of hard to controvert that. So I answered these series of questions. And the one thing I noticed about the tribunal's questions were they wanted to understand the scheme, the system, how it felt, how it fit into the statutory framework. So the question is, what do you do as lawyers? What is the standard of care of the reasonably competent solicitor? And it's interesting because this is my second go round at the tribunal. My first go round was at a case called McLeod, and you should really take a look at that as well. There's a lot of education which can be gleaned from reading these decisions. And here, a mortgage agent held a Terra View license and did things like discharge mortgages, assign mortgages, did all kinds of things. It was essentially a power of sale fraud. And again, real people get hurt. We are the gatekeepers of the system, and we do have to act according to incredibly high standards of perfection. So if you look at my slide 3, what's a vulnerable person? What makes someone vulnerable? Obviously, age, language barrier, sophistication, potential for undue influence. These are themes. These are general themes. Family and other support. Are they isolated? What is the transaction? How does it compare to other transactions that you might have worked on? What is the exit strategy? If somebody says, I'm on a fixed income, I'm 75 years old, I'm taking a mortgage out, the question is, what are you going to do when the mortgage has to be repaid? What's your plan? When you're in grade 1 and grade 2 and you don't do your homework, the teacher says, what's your plan? And it's the same thing here. What is the plan you have to get out from underneath this debt? There's only one exit. And that exit is, I have to sell my house. Now, sometimes that's an acceptable answer. I'm going to sell my house after I do X and Y, because then I'm going to use the proceeds of sale to go live in a retirement home or assisted living. These are all things that are reasonable answers, but our job is to investigate. So if you look at this interesting thing, this is on the Practice Pro Law Pro website. This was a checklist originally developed by Phil Epstein. Thank you. And Phil Epstein is a famous family law practitioner. And he developed this checklist. I just want you to look at the checklist in some detail. So it says I did a conflict check. So I made sure I don't have any conflicts of interest before I take this vulnerable client in, right? So somebody's asked me, they want to retain me, they're 80 years old, and I did a conflict check. So obviously, one thing we've reflected on already is that Harrison had a whole bunch of conflicts that she just sort of said, well, I speak no evil, I hear no evil, I see no evil, right? So you have this idea of I've done a conflict check. And then it says, what documents did I review? Client spoken languages. The client has limited facility with English, so I obtain an interpreter. Can a son be an interpreter? Can the son be in the room with you? Absolutely not. Absolutely not. That client is in the room with you by themselves. Do you know why you're here today? Sometimes I just say, it's a lovely day. Oh, what day is it? And I see, do they know what day it is? Do they know what month it is? Do they know how old they are? These are all telltale signs. I don't like to use the term red flags because you know what? Red flags limit us. Fraud is a tree that grows. We have, if you look over Reed McLeod, if you look at Harrison, the one thing is we don't know what's next, but we can probably guess what's coming next. But fraud is evolving and changing. Great. They said, no, there's no more nosies, right? So they said, no, well, we've outlawed, first we outlawed door knockers, said nobody can knock on doors anymore. And they went, oh, that didn't do it. Shoot. Now we're saying, okay, you can't register new nosies. You know what the problem is? They didn't discharge the old ones, so they're all still sitting there, right? So every time your clients come to sell, they're paying registration costs, et cetera, to have these discharges processed. There's also some funny little distinctions in the act about whether or not the equipment's commercial or whether it's residential, and lawyers have to make decisions. Lawyers are terrible at doing that. So the question is, when this client comes before you, did you ask, I have reviewed the current state of the client's relevant personal, health, family, business circumstances. Do you know how long that takes? Do you know how long you think the average ILA, independent legal advice meeting is? 15 minutes, half an hour. I've seen lots of evidence given. Did you keep any notes? Did you fill out a checklist? Did you open a file? Did you close the file? Who paid? Who paid the account? Someone with a vested interest in it? These are all questions we have to ask ourselves. We have to take our time. If we're going to take these retainers on, you better do them right. Because this checklist has been held in court. There's cases where the judge says they used the ILA checklist. They did everything they could. The person still signed. But there will be times in your career where the client says they sign and you say, you know what? I'm out. I don't want to do this. And you may be calling the police and you may be asking who their support network is so you can refer them to somebody. But the critical thing we're always trying to figure out is, do they understand the nature, the impact, the consequences of this document that's in front of them? And if they don't, surely you should not have them sign in your office. And surely you should give them better advice by just saying, I'm out. Now, how do you do that? Look, phone a friend. You know what's interesting about lawyers? I teach, right? So my name is out there as an educator. You can call me. I take calls from lawyers I don't know all the time. People email me and say, do you have 5 minutes? My whole world is made of 5 minutes. But I do take the time to help people. I say, look, I'm going to mentor. This is in the interest of mentorship. You have to make your own decisions. But here's my experience. And lots of lawyers who are like myself will take your calls. How about the Law Society referral service? I had the great opportunity to do a lunch and learn on real estate matters for the practice advisory group. Man, oh man, they field so many calls. They do such a great job. They're passionate about their jobs. Give them a call. Say, what do I do? What do I need to look for? And they will help you. I've given the telephone number in the paper of the Law Society generally, in the Law Society referral service. Sorry, not the referral service. The practice advisory. Sorry, practice advisory. Practice advisory will help you. And I really feel like if you're going to take these files on, the standard of the reasonably competent solicitor is high. Know your client. Where'd your client come from? Are you getting these clients from the same sources over and over again? The one thing that's interesting about both McLeod and Harrison is these lawyers who are used interchangeably. In McLeod, they actually would strike out a lawyer's name in by hand and then write another one. But the lawyers were all the same, in the same gang, in the same group, right? Now that's really, really transparent. And the fraudsters are smarter than that. But where did the client come from? Who is the client? Who's in their support network? And isolation. How many times did I use the word isolation? This is a critical component. Are they completely isolated? And how much does a renovation cost? Well, I think a lawyer should have some idea that, you know, if you're putting up drywall, it's not $50,000 or $60,000. We have to look at what value is being given and what's being taken away. Your takeaway from my involvement in Harrison isn't necessarily what she did or didn't do. Your takeaway as the reasonably competent solicitor is, what do you need to do? What flags do you need to see? What homework do you need to do? Look at the detail, the work that goes into the ILA, into the independent legal representation. Don't take these things lightly. Withdraw if you have to. And I do understand that lawyers, young lawyers, practice sometimes door law. What's door law? Anything that comes in the door, they have to take it. Why? They have to pay rent. They have their families to feed. I don't take this lightly. But there are times where the best thing you can do, the best advice you can give is, do not sign under any circumstances whatsoever. I refuse to accept this retainer. And I just do under no circumstances. It's not a matter of you acknowledging that I told you not to sign and then you going ahead and signing. I'm telling you, you can't sign. If there's competency issues, you know, how many hats do we have to wear? Now we're supposed to be trained assessors, right? Because we're supposed to know, do you have competency? But in some senses, we have to wear all these hats, and we have to be aware of who our clients are. You know, I'm so grateful. I get to be involved in people's life cycles, right? When people buy their first home, when people are done and they're retiring and they're selling their family home, divorces, estates. I live in their life cycle. But it is the most important financial transaction that most people ever do. As lawyers, we really must remember that. Take it seriously. In 2002, Sid Troyster gave the Law Society special lectures. Neil Smiley, I think he was at Faskin's, he gave a lecture in mortgage fraud. This isn't new. 20 some odd years ago was when we started talking about mortgage fraud. And we're still talking about it today, and we're still not getting it right. So I encourage you, go to CLEs, talk to your friends, phone a friend, phone practice advisory if you're not sure, but do your homework. And the system is better. We do have to safeguard these vulnerable groups. It is our job. And I want you to take it seriously. Call me, joel@kadishlaw.com. Call lots of people. You can call Greg. You can call. I'm just inviting strangers to call you now. And I do emphasize the word strange. But please take these matters seriously. Give them the care that they need, and the system will be protected if we all do a better job. Thanks for listening, and now we'll get back to talking more about Harrison.
Thank you.
My pleasure. Have the clicker.
There we
I
go.
feel like it's the conch from.
Here we go.
Yeah.
All right. Thanks, Joel. My name is Ken Doring. I'm a manager in investigation services at the Law Society. I myself am not a lawyer. I'm a CPA, so I'm not as verbose or as animated as Joel is, and I don't have the benefit of doing lots of CPD at the Law Society. But I'll do my best to.
You're going to be fine.
Yeah. There we go.
I trust you.
There we go. All right. So we heard about overview of the case. We have a professional misconduct case with regards to the LSO and Danielle Harrison, and she was found on 4 allegations. The decision was at the end of July. We are still waiting for the penalty and the costs, and that will be coming out in due course. We also discussed about the systemic vulnerabilities that came out of this, the weaknesses that they're currently around mortgages and notices of security interest, which now have, since with the as of last year, are no longer permitted. and it showed the exploitation of mortgages and the NOSIs. And then also, as the panel have been talking about, the role of lawyers, their critical responsibility to uphold the ethics and protect, ultimately protect the public with regards to these transactions. The lawyers are, they are the ones who should be trusted the most. These are the ones that people come to facilitate these transactions and rely on their expertise. So, it's really critical that the lawyers conduct themselves accordingly. So we talked about the timeline and culpability levels, and I'll get into that a little bit as well. And then also about enforcement and guide practitioners, enforcement to the guide and practitioners and regulators. It's funny because this has been going on, this door-to-door sales and the escalation to mortgages on the elderly and the vulnerable. And door-to-door sales have, supposedly have been are not permitted. But as of last week, over the last couple of weeks, I've had people coming to my door, supposedly Rogers or supposedly Bell. They knock on the door and then they stand back down a few steps because they hear I've got a big dog that's barking like crazy. So they stand back. And then once they realize my dog is very friendly and he sits there and has got his happy smile, these guys start coming up the steps and they start, asking me questions. And I'm almost 100% sure that these are not legitimate Bell or Rogers salespeople. I would hope that these organizations, these companies are smart enough now not to put people out on these door-to-door sales like this. Given all the attention, there's a ton of media that with the Harrison matter that has been reported through CBC, Marketplace, all these all kinds of attention. So I had one of them who was very aggressive and was coming up, and he got to my door. And finally, I just gave him an expletive and closed the door because, rest assured, they are still working on these scams. Okay. Right. So steps taken by the Law Society. So the scheme was happening in 2021. ACE gets wind of it and they start getting things on their plate around the end of 2021. We get the first matter referred to us in April of 2022. It gets triaged through our intake and resolution, ultimately into the Investigation Services Department. Between April 2022 and May 2023, we have about 10 cases that we are investigating. These were each one of them were different victims, but a lot of these cases came through ACE. ACE assisted the elderly in putting their complaint together, getting the materials together to get the complaint going in the investigation. May 2023, we're at a point where we have assembled information from these documents from these cases, and we have at this point reasonable suspicion or reasonable grounds that there's significant risk of harm to the public and to the public interest in the administration of justice. So this is the threshold that we need to put to the tribunal to say, look, we have something that's serious here, and we are looking to get interim measures on the licensee. And in this case, we were seeking interlocutory suspension until we finish the investigations and we take the matter to proceeding. We get a couple more cases that come in and they get piled on. And then in November 2023, the licensee appeals the suspension or files a notice to appeal. The panel agrees, allows the appeal, but even though they allowed the appeal, they still ordered the suspension, that the licensee be suspended. Sometimes what happens is the panel may allow until the appeal is heard for the licensee to practice maybe a restricted practice or whatever. But in this case, the licensee was still suspended. So the appeal process goes through. In February 2024, there's a decision again by the tribunal to say, yes, the licensee remains suspended on an interlocutory basis. So at this point, our investigation is ongoing. There's always whenever there's a suspension order like this, there's still the obligation of the licensee to continue to respond to the Law Society to cooperate with investigations. It doesn't mean they can just kind of sit there and do nothing. And then in July 2025, I think July 31st, I believe, we get a finding for the Tribunal of Professional Misconduct. So the licensee is found on the 4 allegations that Joel had mentioned, or maybe Greg. And so now we are waiting on a decision on the penalty and costs, and that will come in due course. All right. So while all this was going on, lots of discussion within the professional regulation that we needed to get some notices out to the profession. So the first one was on August 16th, 2023. And this was a notice out regarding exploitative loan agreements. And so the notice was out there to talk about that we've seen many instances now where there's vulnerable senior citizens that have been induced into these loan agreements. It's predatory lending, and it's been targeting these elderly and the vulnerable. At this point, we've had lots of information come in, and we've typically, when we're doing investigations, we assemble all the information. Looking patterns is one of the things that we're looking for. And as we've talked about here, and as Greg showed on his chart, there's certainly a pattern that the victims were elderly, or again, they were some sort of disability. They were low income. The loans were 1 year on 25% interest. And these are victims. These are elderly, with many that have no mortgages on their property. They have access to lines of credit. So why are these elderly people being induced into these short-term loans at very high interest rates? Okay, and we also bring to light the fact that there's these victims are being that they were being registered with these notices of security interest. Like I said, there's consumer products and so on. The nests were some of the things that were nosies were being put on. And it's funny, when this first came out, and myself and our colleagues, when nosies were being mentioned in the first complaints, we had no idea what a nosy was. So we were all of a sudden scrambling what is a nosy? Should have called maybe Joel right away and figured that out. But a lot of internet search and trying to understand what they are. And one of the things that I found really interesting was that these nosies were being registered against on title without the person even knowing that they're being registered. I couldn't believe that could actually happen. But so that was the start of the scheme, and then as they talked about, it snowballed in some cases to a micro mortgage. Hey. Oh, this is separate. Okay. Yeah. And then it escalated to these large mortgages that went onto people's properties. Yeah, I can't link to that document. So the next thing that we had, the next notice that went out was on June 13th on 2024. And this was after the bill, the Homeowners Act, the Homeowners Protection Act that came out on June the 5th, where they banned the registration of nosies for consumer goods on the land registry, and that any current nosies that were registered to get on title were expired as of June the 5th, 2024. So we put out a notice on the 13th of June. Again, it's alerting the risks of of the nosies that are being registered, and being on guard about facilitating these kind of transactions. Okay. And then the last link down there is the practice supports and resources. And again, it's a great resource for any of you dealing in, if you're getting into these transactions, hopefully not any longer, but it's a really good section about explaining what exploitative loan agreements are, about lawyers' obligations, the red flags to look out for. So there's a whole host of information there that is a good resource for anybody who may be sort of getting into something like this. And it was, as I said, fraud is like a tree, so we don't know sort of what the next branch is that's going to grow from there. Keep looking at the Law Society website for these practice resources. We talked a little bit about the key dates and timelines. The initial engagement by Harrison was retained in February 2021. The emergence of the issue started coming in June 2021 when some of these mortgages were coming due. And then shortly after that were complaints that were coming into ACE in the latter part of 2021. Then we get into early 2022. The police are starting to get involved. They're getting calls from victims and from I suspect maybe Greg. And also the shadow practice was being utilized at this point. And then finally, the disciplinary measures that took place May 2023, like I said, was the initial interlocutory suspension. And then by July 2025, we've got the finding on the allegations. Greg talked a bit about the fraud culpability. So again, it was sort of 4 phases. There's the negligence phase that was very early on. Then it became reckless. And then where she was ignoring the clear warnings and some of the complaints, to the willful blindness, which again gets a little more serious. There was suspicion of fraud, but she was deliberately avoiding that. And then the actual knowledge when she was running transactions through her shadow practice and keeping that away from both KMB and from the Law Society. And what was interesting about the decision in Harrison is that the panel really took its time in explaining sort of the various levels of culpability. We don't always get that. So they were very diligent in setting out the timelines, what happened right from the beginning in 2021, right until the end when the matter came to hearing.
And again, not to interrupt, but it's like you can do something 2 times. You can do something 5 times, but the more times it occurred, the more they found her. The more the culpability came. So, that's also the warning is if you see someone and they're coming in with these multiple transactions, look behind it. Just take a look.
Yeah, you can't plead ignorance the whole time, and at some point you got to start looking into things. Again, it's hard for me to kind of understand, even at the first couple of instances of being involved in these sort of transactions. A 1-year 25% mortgage for an elderly. How are they going to, as you said, how are they going to get out of this? And these are the questions that a competent lawyer should be asking themselves. Okay, again, red flags that were identified, we've gone over that. Generally, we had vulnerable borrowers, we had high costs and fees. Not only was the interest rates very high, but the broker fees were quite excessive. There's the legal and ethical issues with regards to conflicts of interest, the false stat decks that were signed off. And then the refusals by a couple of title insurers that would not insure the transactions. Okay. Investigative insights, and this is sort of consistent. Some of these are consistent with a lot of the investigations that we do. Pattern recognition, we're always looking for patterns, and as Joel just said, maybe if you do it one time, it may be negligence, it may be something it was just done by mistake. But in this case, it was a repeated transactions, and Greg's list showed the whole list of 40 transactions where there was consistency throughout. The document inconsistencies, we look at that. So in some instances, there were missing lender signatures and inflated discharge amounts that did not match the actual mortgages. Client vulnerabilities we've talked about, and then the concealment and non-cooperation, which was certainly an issue on our part. When we're asking for client ledgers or trust ledgers or any kind of trust accounting, we're asking for it all. the Harrison in this case was purposely only giving us the KMB stuff. And then it came to light that she was actually, she created the shadow practice, had an excuse as to why she did it. But then we got documents that proved that she was doing these transactions off book from KMB.
And just to understand, she worked at a firm. The firm's name is KMB. And then she ran this other shadow practice in her own name. And so after she stopped putting the transactions through KMB, she was putting them through this completely through the shadow transaction. So you can get the feel for what that meant in terms of her integrity, right?
And when she I may be wrong in this, but I believe when she created her Harrison Legal or whatever it was, I don't recall that it was registered with the Law Society. There was no declaration of the trust account that she had a trust account. Okay.
Greg says no. It wasn't
No. Okay. Yeah. Thanks. Enforcement considerations. So again, the things that we looked at, we got the interim suspension in order to prevent any further harm and to protect the public interest. The deterrence and the discipline response. So it was important for us to get the sort of outcome that we did to show to the profession that we don't take these things lightly. That this licensee is going to be suffering some serious consequences. And then it brought to light the regulatory oversight and the risks that were sort of being brought about through this investigation or through these investigations. Okay, and transparency and firm accountability. And so there's the issue of there was a lack of supervision at KMB to kind of let her do her thing. But so she did. And then she, again, when she finished with doing stuff with KMB, they told her to stop doing it. She started running the transactions through her shadow firm and hiding, the information from us and from anybody else. So that really speaks to the integrity. Okay. So lastly, at the end of this, it speaks to the vigilance that licensees must hold themselves to in whenever they're doing transactions, upholding your ethical standards. There's the need for strong oversight. At the end of the day, the scheme was that we had tons of evidence that these borrowers that were elders were put at risk of losing their homes, starting with the loans that were registered as nosies and converting into high interest loans that these borrowers or these elderlies had no hope of getting out of.
I have a question. Is there compensation of any kind available to these victims or not really? They just lose.
It's a great question.
Yeah, I just don't know the answer.
I mean, the LSO compensation fund, I'm sure it's a fund of last resort, and I'm, from my understanding, may not apply in this situation because funds weren't actually taken from the client by Ms. Harrison herself.
Understood.
It's very difficult.
So other than LawPro or civil, LawPro is the lawyer's insurance company, but other than LawPro or civil remedies, there's no compensation.
I not that I'm aware of, but I'm sure.
Yeah, negligent civil and we said that the comp fund is being the one of last resort. So
got it.
And the issue we have is the volume and one LawPro coverage. We got 40 transactions and a maximum amount on the insurance policy.
So I guess the reason I asked is because as the gatekeepers of the system, we do have to remember that if we make a mistake of legal knowledge and we make a Planning Act violation, those things can be repaired. Here you have irreparable harm. And I think as lawyers, we have to remember that.
Yeah, and I think what Bethany's saying is that when you have 40 claimants against one lawyer with an insurance policy with an upper limit, the value of those claims far exceeds the policy limits of the policy. And so it's rather like going after a bankrupt estate where the bankrupt debtor may owe far more than they have to distribute. And that is the exact situation of our clients that we've been acting for.
Especially when each individual claim is in the hundreds of thousands of dollars, right? So I've got a client with a $940,000 mortgage.
We're
for
getting
this fraud.
pennies on the dollar, like if that.
They lose their home. It's just, I mean, unless the lender is found somehow to be involved, which in the CCI case,
Was
may,
clear.
yeah, I don't want anyone suing me. But some of the lenders aren't a related party. So we find ourselves in a very difficult situation.
No, well, the problem was that these what fraudulent mortgage companies would then assign the debt to a bona fide purchaser of value without notice, or they would refinance it before that 1 year that would be up. So they'd refinance it with bring the same borrower in, same victim, sometimes the same lawyer or different lawyer, but they'd be refinancing really expensive debt with something that's more reasonable, where the reasonably competent solicitor might not see the red flag. So they bring in a 6% mortgage to refinance. They pull out but then it would just churn and just pretty much stack more debt or pay out the fraudsters along the way. But going into a lawyer's office, they wouldn't necessarily see the red flags in that transaction alone, because they wouldn't see the high interest. They may not see the capacity issues. They may the questions they may ask would be, is this a good idea or a bad idea? And they're getting out of a really bad situation. So it looks pretty good, for that lawyer at that meeting. But
and Joel says, when you search title, search with deleted instruments.
Yes.
But you all just said yes. The reason that I'm telling you to search with deleted instruments is so that you can see the historical pattern. That is one of the red flags. That is a flag that we must look at. So we all use law clerks, and it's great to use law clerks, but at the same time, we really must examine those parcels to look for those histories, because you would have seen 8 nosies, a number of mortgages before the quote unquote real refinance.
Yeah. And I would even say, I still think it's very clear red flags, even that scenario, again, what's the exit plan?
Again,
What's this money being used for? Additional money is being borrowed. Why? Who is it going to? Renovations? Do renovations cost $300,000 on a home that's worth $400,000?
and I actually had no idea until now that they were brilliant enough to do that last refinance.
Oh yeah.
right?
I've got one with 4 within 18 months.
Wow.
Yeah.
and by the time it gets to that level, we can't do anything about it.
No.
Because we can't go to title insurance for
No.
fraud. We can't go to land titles insurance fund. You're out of luck. And by that time, the fraudsters are long gone, and they've already paid themselves out on the nosy scam. They paid themselves out at 10x what the value of that nosy was. Then they put a mortgage on the same company. They pay themselves out their lender fees, broker fees, and then they've just churned it over to an innocent lender. We'll say, whether or not they're innocent or not is just a battle that these people can't afford to deal with. So by the time it gets to a lot of lawyers, it looks like a viable exit strategy for that problem that they're in. But do the searches, figure out the pattern, and then at that point you can actually do something about it, as opposed to completing that transaction and then they're really out of luck. So
is it fair to say that once the horse is out of the barn in terms of the mortgage money having been advanced, or if it's an improvident sale, the sale proceeds having been dispersed, recovery is sometimes possible, but usually very difficult and often impossible?
Yeah, for sure.
And so looking at the situation of a young or a naive or an inattentive lawyer, what are some of the things that they should be doing really to make sure that they don't fall down this slope when they're in the process of doing something? Maybe they've done a transaction or 5 transactions already, and they realize something is wrong here. One thing I'm wondering about is the role of virtual interviews and virtual signings. Does that have any role in the aspect of, Joel, I thought you were very astute and instructive on know your client.
Yeah.
And I don't know how that fits in with know your client when you're doing all of this virtually.
So just give people a bit of history. In the pre-COVID world, we saw all of our clients in person. And if we didn't see them in person because they were in another country, there were specific agency rules that we had to follow in hiring another lawyer in that jurisdiction to prove their identity and things of that nature. So there was specific protocols. When COVID happens, we started doing these virtual signups. So we're using DocuSign, Zoom, various platforms. The fraudsters loved it because they were, somebody would hold up a driver's license or a PR card to a phone camera and say, "Here's my ID," and all of a sudden we had this boom in fraudulent mortgages based on ID scams. And so now we use identification verification software, IDV software, through various providers to help us prove their identity. But what that doesn't help us with is, how do we know there's not somebody else? We talked about this in our group meeting, but how do we know there's not somebody else in the room?
And there was.
And there always is. There always is.
These seniors didn't have internet. They didn't have computers.
Right. So the bad guys would say, "Use my phone to call the lawyer."
Well, here, setting up the whole Zoom, and they're behind the screen.
Correct.
Yeah.
Holding up yes, no,
Yeah.
yes, no.
How to answer the questions. Yeah.
Sure.
We have their scripts. Right?
And so it raises the question between expediency, that is using technology and using the platforms that are available, and giving appropriate and great legal advice. And sometimes we do have to go the extra step, especially when we know we're dealing with seniors who may have limited technological capabilities. And if we want to take that retainer, we should think about at least either bringing them in or going to them, because the retainer isn't dependent, right? The retainer doesn't say just because it's expedient, we should use these technologies. The retainer is to make sure that the client understands the nature, consequences. What am I signing and what will it do? And because of that, there are times where we do have to have those in-person meetings, even though the rules will tell us this is what you can do. But then I always ask, is it what I should do? And there's a really big difference between those two things. I have a lot of experience, but if you're inexperienced, phone somebody, call Practice Advisory, use your best efforts to know your client.
Joel, we have a question coming up from Jan Goddard. But Jan, before you ask your question, I just wanted to follow up on your point. 40 years ago, when I got called to the bar, I was very soon what you might call a door lawyer.
Yeah, of course.
I was a young lawyer in a sole practice, feeding my family with my law degree. And what came through the door was what I did.
Right.
And what I would do as a sole practitioner up in Barrie is, when I had problems, and I would call up the most senior lawyer I know, the most knowledgeable lawyer I knew in the area, and ask for advice. Sometimes it was a construction law lawyer in Bay Street who would offer me his time, let me see that lawyer in his office to help sort out the problem. More often it was the late Richard Clark, who would later became the last appointee to the old Supreme Court of Ontario. And every so often I would pack up my files and visit Richard at his office at 7:30 in the morning, and Richard would straighten me out and tell me what to do. And of all the times I called this most senior experienced lawyer for help, only once did someone ever say, "No, I can't do that, I have a conflict."
Right.
And to young lawyers, I don't think we can overstate the importance of mentorship.
Absolutely.
And I think you'll find when we go to court, we say, "My friend said this." And sometimes it's hard to believe that our colleagues actually are our friends. And if we ask for advice and mentorship, I think to all the young lawyers and the old lawyers in the crowd, we'll find it much easier to find than we imagine. Jan, you have a question?
Yes. Speaking as a partner in a law firm and a former managing partner, I think my question really is for you, Ken. I mean, when I first heard about the Harrison case a couple of years ago, I sort of put my head between my hands and went, "Oh my God, this happened within a sizable law firm.
Yeah.
What the heck was going on?" And so I'm interested in your views on what the role of the law firm was and what a prudent management structure in a law firm would look like to avoid these kinds of things happening,
That's a
where a
great
rogue
question.
lawyer within a law firm is operating in the fashion that Harrison was.
Great question.
Yeah, well, in the case of K&B is that they were bringing on somebody who had real estate practice. My understanding is that they didn't have much in the way of with real estate. So here comes somebody who has a real estate book of business and brought her in to do that. Now, again, they kind of let her come in and run roughshod without any kind of oversight. And she, it's a combination of not sort of checking in to see, okay, how are things going? And then also it was, again, difficult because Harrison would not go to any of the partners to ask questions. Like if initially the intention was, to do good on these transactions and then kind of go, oh, something's wrong. If that was the intention, I don't think she ever went to anybody to say, look, I've got the stuff in front of me and I'm not sure that this is legitimate. So, again, it's the requirement, the supervisory, and it's a little bit tough, I guess, when you're bringing in a lawyer into the firm to.
I'm also reminded of the movie Wall Street. Gordon Gekko, right? Greed is good, and unfortunately, I think her billings were quite good, and so they saw that as, she's doing very well in her practice area.
But if the firm didn't really have real estate as a practice area, to me, that's a huge risk to bring in someone from outside to practice in an area that you don't have the expertise and infrastructure for within your own firm. I mean, that's just an observation, maybe not a question, but I think it's worth mentioning because there may be people who are watching online who would contemplate doing something like that. And it's a huge risk.
Correct me if I'm wrong, but I think there was one partner doing the real estate and she was brought in as the associate.
Yeah.
So there was,
and then that partner left.
Yeah.
and then that's where, maybe I don't, things went off rails maybe.
And that partner apparently said that she was going to take Harrison with her, and then Harrison stayed, and that was one of the quote unquote excuses for the shadow practice. But I don't think it means you can't bring them on. I think it means you have to have oversight. In other words, you still have to know, you're billing X. Where do your billings emanate? What are the files that you're working on? Who are your key people that your key sources of business? Because if somebody said, well, I have a real estate agent from agency X that you've heard of, or a mortgage investment corporation, or a bank that's sending you work, and those files bear out, then I think that's one thing. But in this case, I don't know what they did or didn't do, but maybe had they asked a few critical questions, they would have found out quite easily about the source of the work and the nature of the work. And maybe they could have shut it down, but I don't know. I'm only speculating.
And in the generic sense, doesn't lack of supervision really resonate throughout the law practice? I mean, not just as to the quality and integrity of the client work, but also dealing with the trust funds. I mean,
Of course.
from the spectator box, watching when things have blown up over the years, and a lawyer within a firm has run off with a lot of money. There were silos within the firm,
Correct,
where there was no central control watching over the trust funds, or the lawyer who was creating the silo would never leave the office for more than a weekend for fear that someone else would discover what he's doing. I do have just a couple of quick online questions. Ken, while you were speaking, somebody asked, how do you contact the Law Society to make a complaint? Is your number still 416-977-3300?
Yep.
Have you got that? Not that I've ever had to call them before, but
There is also an online.
The online is
so there's a portal where you can make a complaint. If you look on the Law Society website, there's
everything's through the
drop down menu, and it's not difficult to make a complaint against the lawyer. I recently reported a lawyer for abandoning their practice. It's the whole process is not difficult. We are officers of the court.
Yeah. And another comment I'll read from an anonymous attendee. I am really enjoying this presentation. I feel standard of care for vulnerable clients is extremely important topic and would be valuable to will and POA drafting lawyers, among others. I guess, is there a general endorsement that the topic is not so much NOCs, which are fading from view, but it's really transferable to all other areas of practice where we're giving legal advice to.
You know what's great on the Law Society website? I wrote this down before, but if you look, Kim Whaley, who's a well-known estate litigation lawyer, she's written a great paper that's posted on the website, and if you're looking for general guidance in terms of undue influence and these things, and wills and estates is another fantastic area for these kinds of misdeeds. So use the resources that are there. This paper is absolutely, when you read it, you'll either be terrified and never write another will, or you'll improve the standard of care that you're giving to others. But recently, I did read that article on undue influence, and it's just tremendous because it's a lot of the things that a young lawyer might not think about. That's right there. And be lifelong learners. Be lifelong. Never think that you know everything. I learn. There's a group of us who talk all the time, and we have collectively over 100 years of experience, and we're lifelong learners, and we enjoy what we do and we're passionate about it.
Those use of those resources are so important. When I was a criminal defense lawyer 30 to 40 years ago, I followed a guide that was produced by the Law Society on how to represent a criminal client. And in every of the many hundreds of criminal cases I handled, I would look at the checklist of what to do. 100%. It's like a pilot flying a plane. Before you take off, you do certain things. Elizabeth, is it Elizabeth? Elizabeth Moore, at 6 p.m., you were waiting in line a long time, but you're the last question, so we can go get some food afterwards.
It's about coming back to the issue of virtual and in person. A number of you mentioned a few things. Not being a lawyer, but being a member of the public and being a professional that's involved to some degree, as I'm a neuropsychologist working with seniors and also a designated capacity assessor and actually a consultant to the capacity assessment office. There doesn't seem to be a specific pronouncement about in-person versus virtual, and whether or not one has certain downsides or disadvantages with regards to bringing up an issue of undue influence, particularly around potential vulnerable seniors. The other thing, though, is as a member of the public, so many of our tribunals, if not all of them, are now solely virtual. So is there not some perhaps mixed message going on there with regards to the determination of certain aspects of the law and the access to the law for members of the public?
I think the Law Society's guidance is pretty clear.
Okay.
I think the Law Society's guidance in terms of how we use the virtual tours, the virtual platforms. And because of COVID, we can't get it back in the box, right? The joke I make is that if you ask a millennial client, I say, come to my office at 3:00 on a Tuesday, they'll be like, excuse me, and they'll literally find another lawyer or law firm to deal with that does offer virtual appointments. So it's out of the box. But having said that, I think the Law Society, Law Pro, and other educators have spent a lot of time and energy on how to do it properly. I participated in a panel during COVID. It was like an emergency panel that was given on how to attempt to do it properly. I access to justice is always on our minds. I think it should be on every lawyer's minds in terms of standard of care. And I don't think it's just I don't think it's just that the guidelines are there. I think we also have to use our own interpretive skills and, again, know your client. And when we come across a senior who otherwise we know, identification verification is very hard for some of our seniors. And we ask them to download an app, and then we ask them to take a selfie, and we ask them to upload pictures of their passport and driver's license or purple card. It can be daunting. So I say to them, don't worry, come in. I'll stay till 6. I'm good. Come in. If you're not comfortable using IDV. And then the Law Society has given me guidance about the difference between those two appointments and what I have to do and not. The title insurers are helping me. They're our partner in this, right? And we're working as best we can within the system that really got disrupted, if you will, by COVID. And by the way, what I'm told from all the stakeholders is identification and verification is working. So we've cut down that fraud. Now wire fraud's gone crazy, right? That has nothing to do with this audience. But every time when we say it's a living tree, every time we try and fix something else comes up. I think the guidance is there. I think you really have to study it. I think you really have to look for it. Be lifelong learners. Be curious about your clients. Be curious about the system. Love what you do. Have some passion for it. If you're just running a factory, if you're just, you're going to run into trouble. That's for sure, because we can't do it on that basis. Vulnerability is not the only thing. Right? I can't paint a house. I would do an absolutely terrible job. Everyone has unique abilities. I respect the differences in my client base on many bases, not just vulnerability, right? And I think we do have to appreciate where our clients come from.
I know it's 6 o'clock, but we have one more. I said this would be the last question. We have one question from Karen Stewart.
Yay, Karen.
The question is, would you like to present the question?
Sure, I'll do that. But before I do that, just one clarification regarding the initial question with regards to complaints into the Law Society. Again, we have a portal account called LSO Connects, which everything runs through now. All of the communications, all submissions, and everything goes through LSO Connect. So if anybody, whether it's a licensee or a member of the public, wants to make a complaint to the Law Society, again, it's quite easy to do by going on to the lso.ca, and it'll direct you right to a form to fill out the complaint. Okay. There's a question from Karen Stewart. Says, this is for Law Society. What is the typical amount of time from complaint to decision? Was 3 years in this case typical? There's nothing typical. Again, it's like anything, that the sort of the complexity of the matters we can shut down cases quite quickly. And in this case, from the time of instruction to the time there's a decision, like in this case, we had interim measures taking place, PMCs, PHCs, and then an appeal to the suspension. So there's a lot of things that were going on in this case. And so, 3 years, is it typical? Not really. But again, it's, we try to do these as expeditiously as we can. And again, caseload is not an excuse, but we're looking at severity. We're looking at the impact on the public. We're looking at all these sort of things to move things forward. So there is no real sort of normal, if you want to say that.
With that, I'm going to close the panel discussion. Before we do that, I would like to acknowledge and thank the Law Society and the Ontario Bar Association for all the instrumental help in their partnership in presenting this, and also, to the ACE Board of Directors and our special lecture committee, or who are all volunteers, And our special lecture committee is led by our board member, Lindsay Van Roosendaal, who's here at the OBA as well. And our profound thanks to those who made this possible, as well as to our volunteer speakers. All of these, Bethany lives and breathes this work. I don't know where she gets time to raise her family and do the other things that she does. Joel and Greg are in private practice, freely donating their time to do this and the preparation for it. We're very grateful to it. And Ken has stepped forward on behalf of the Law Society to fill, I think, a very important function. And thank all of you who have attended here in person. I think we have probably about 30 to 35 people here in person, and we had 441 persons register online. The maximum of the system, I think, is probably 500 people. It's quite a strong response. We'll now conclude the proceedings, and for those who are present here in person, we have refreshments waiting. Thank you.
Thank you, Greg. Thank you, Greg. Thank you so much.